Missouri versus Biden. The big tech censorship lawsuit is well underway. This was something that got filed back in May, and I wasn't real sure if this was going to have any legs, and it looks like it does. We actually see that on the 12th, just about 2 weeks ago, there was a discovery order from the judge that said the states are entitled to learn more from these social media companies about their censorship collusion with guys like Dr. Fauci, with guys like the CDC, with guys like the DHS to sort of craft a narrative on social media to serve them in a way that implicates constitutional rights, free speech, and your right to participate in American life. And so we've got a lot to get to. As I mentioned, this involves Dr. Fauci and many others. I want to share with you just the actual complaint, because it's a pretty interesting complaint. And I actually opened this up on our PDF viewer that allows us to draw on this puppy. And so let's get this thing queued up. As you can see, number of people are listed in this. And you see some pretty big names on here. Joe Biden. Oh, yeah, he's the president. Oh, Jen Psaki. She's here, along with Vivek Murthy, Surgeon General of the United States. Xavier Becerra, of course, Department of Health and Human Services. There he is, Dr. Fauci, over from the NIAID, National Institute for Infectious Diseases. Alejandro Mayorkas, over from Department of Homeland Security. Jen Easterly. And guess who this is? Nina Jankowicz. Remember Jankowicz? She was over at the Disinformation Governance Board, and she was somebody who was part of sort of that censorship cabal. All of them named as defendants in this lawsuit. It's a fairly decently sized lawsuit, 84 pages. I'm going to just hit the highlights on this, and then I want to show you the discovery order. So sort of remember what's happening here. There's a complaint. This is the very first document that starts the whole lawsuit off, and it's from Missouri versus Missouri and Louisiana. So shout outs to our friends in Missouri and Louisiana through their attorney generals, Schmidt and Landry. They're suing all the Biden people, and they're saying, look, you colluded and you censored free speech in America, and that's illegal. They write, in 1783, George Washington warned us that, quote, if freedom of speech may be taken away, then dumb and silent we may be led like sheep to the slaughter. He said that to the officers of the Army back on March 15th, 1783. The freedom of speech in the United States now faces one of its greatest assaults by the federal government in our nation's history. And they cite some case law over from the Supreme Court case from 2021. They say, over the last several years, beginning with express and implied threats from government officials, culminating in the Biden administration's open and explicit censorship programs, these have threatened and cajoled media companies for years to censor viewpoints and speakers disfavored by the left. They say senior government officials in the executive branch have moved into a phase of open collusion, obviously, with social media companies to suppress disfavored speakers' viewpoints and content on social media platforms under the Orwellian guise of halting disinformation, misinformation, and malinformation. And obviously, right, like we've been the subject of that here. You've seen a lot of it. You've heard me rail against it because this channel in particular, you know, I'm trying to make some changes on this channel just to show you, or just to sort of see if we can pop outside of the little bubble that they put around us, because none of our stuff shows up in search. It's very, very limited in terms of its recommendations to other people. So thank you for sharing this with people and inviting them to come join us on our live show. But right, they craft the conversation. Now they're being sued for it. It says here, the aggressive censorship that the defendants, meaning Psaki and Fauci and Biden and all those people, that they have procured, they say it constitutes government action. Okay, it is the government. Many people on the left, they say, well, they're private companies. Facebook can do whatever they want. And Twitter and YouTube, they can do whatever they want. But there's a distinction in our law. It's called government action. When the government is sort of encouraging private individuals to do things at the behest of the government, it's kind of like the government is doing the thing, right? They can't outsource all of this stuff to private actors. And they give us 5 reasons. They say, look, absent federal intervention, well, we'll skip all of those. You get the point that they're trying to make. They say defendants' campaign of censorship from the Bidens has finally culminated with the creation of the Disinformation Governance Board. Janky old Jankowicz saying this is like Oceana's Ministry of Truth, saying our Constitution stands against the Disinformation Governance Board. And as a direct result of all of these changes that came out of the Biden administration, we have an unprecedented rise of censorship and a suppression of free speech, including core political speech on social media platforms, which is so obvious. They banned the president of the United States from social media. The sitting president banned. Not just fringe views, but perfectly legitimate, responsible viewpoints and speakers have been unlawfully and unconstitutionally silenced in the modern public square. Point I've been screaming about here for a long time, right? There is no place to go out and debate in the public square, especially when you lock us all in our homes. These types of restrictions gravely threaten the fundamental right of free speech and free discourse for all citizens in Missouri, Louisiana, and America on social media and elsewhere. And so you can see, right, the rest of this is going to give us a lot of legalese, and we'll just scroll all the way to the bottom and see if we can see what the conclusion is going to point us to before we get to our certificate of service. And so there it is. Count all the different counts that they're charging them with. Here's the prayer for relief, right? They want the court to declare that the conduct of the Biden administration violates the First Amendment and the state constitutions, and declare that their conduct is outside the scope of the law, outside the scope of their power. Declare the defendant and their conduct violates the APA, which we actually talked about yesterday in the other case, the transgender lawsuit case, and preliminarily and permanently enjoin all of these people from engaging in their conduct moving forward, signed off on by the two attorneys general and their sort of deputies, filed now out of the district court. So all of that is a interesting lawsuit, and I think it makes a very astute point. And so what happened, if you actually go over to the court docket, the way this stuff works is you file a lawsuit and then they file a response, and there's a back and forth. But ultimately, both sides, even in criminal cases, they want to get to what's called discovery. You may have seen this and heard about this in other cases that you followed. If we can just get to discovery and see what they've got in there, then we'll be able to really, really see some interesting things. Here now, we were fighting over that. These states, they want discovery, right? They want this to happen and they want it now. And the defense, or here, this is the government, this is the states versus the feds. So it's the plaintiffs are the states who say this censorship was illegal versus the government who says, no, we can do whatever we want. This order came out just about 2 weeks ago, and we just set dates on all of this literally recently. And we've got deadlines coming up. Yeah, okay. So let me show you this. On the 12th, we had this official ruling that came out from the judge. The judge's name is Kayla McCluskey and Judge Terry Dowdy. They are out of the Western District of Louisiana. And here's what they say. This is a discovery order. Look at this. Granted, the plaintiff's state's motion for expedited preliminary discovery is granted in accordance with the schedule set forward. So that's like a big whoa. That's a big win right there. You're going, whoa. I almost have a Jill Sanborn face. Whoa. That's crazy. They're going to actually grant this. So they're going to say that the states have a right to go get discovery from the Fauci and the Facebook. What? Those conversations? That's crazy. But it's true. It's real. Here, let's take a look at this. It says, this is coming from the judge. So the judge writes, okay, look, all these motions are filed. The complaint has been already submitted. And now there's a back and forth about discovery. The defense, the government, the feds, they don't want to give any of that stuff over, of course. And so they're sort of, fighting this. So the judge says, all right, children, sit down. I've made my ruling. Comes out and says, before this court is a motion for expedited discovery filed by Missouri and Louisiana, the states. They want those documents. And an opposition was filed on July 1st by the feds. Reply came out from the states July 7th. And for the reasons set forth, I am granting the state's motion. Meaning they're going to get some discovery on this thing. I'm going to show you what they're going to get. And it sounds pretty good so far. But here's the background. The judge says on May 5th, the plaintiffs filed a complaint. That's the states, right? Louisiana and Missouri, they filed against the government. We already covered that, but the court summarizes this for us nicely. They say in the complaint, the plaintiff states say the government defendants have colluded with and or coerced social media companies to suppress disfavored speakers, viewpoints, and other content on social media. They say that this suppression was a violation of the First Amendment of the Constitution and all the different states' rights. They say all of these people are involved. Look at all these names: Biden, Psaki, Murthy, Becerra, Fauci, Mayorkas, Easterly, and the janky of the jankies, Nina Jankowicz. The complaint, says the judge, further alleges that the plaintiff states have created a disinformation governance board within the Department of Homeland Security to use, label, and pressure censorship of disfavored content. Obviously, they created that, right? We saw it. Like, Mayorkas was sitting there answering questions about it. So in the complaint, the states, they give us several examples of the suppression of free speech, right? Here's a list, 4 of them, easy. Number 1, the Hunter Biden laptop story prior to the 2020 presidential election, obviously suppressed. Speech about the lab leak theory of the COVID-19 origin, obviously suppressed. Speech about the efficiency of masks and the lockdown, suppressed. Your boy got suspended from YouTube for a week over that crap and thrown off Discord. Speech about election integrity and security of voting by mail, right? That's the one that got us booted off of that garbage chat platform. And it is a lot of misinformation and disinformation that has been spread around all over the place at the hands of the government. But the point is, they're censoring oppositional viewpoints. So the states, the judge says the states set forth specific government defendants and the actions that they have taken to suppress free speech, right? They went through that in their 87-page complaint. The states say that free speech is the bedrock of American liberty and that the government defendants are in violation of the First Amendment. They say that they are suppressing free speech by labeling it as misinformation, which is obvious. That's the whole point. It's being labeled that way, obviously, right? So the states now seek to enforce the plaintiff states' own laws and the constitutions on behalf of themselves and on behalf of their citizens. We're fighting to enforce our own rights since you're not even doing it. And they go through, we've got 4 counts. We say First Amendment violation by all government defendants, statutory authority exceeded against all government defendants, violation of the APA by Health and Human Services, and violation of the APA by the Department of Homeland Security. On June 14th, then, plaintiffs, they filed a motion for a preliminary injunction. They wanted to prohibit the government from taking steps to demand, urge, and encourage or otherwise induce social media companies to censor, we've been that, suppress, yep, got that one, remove, done, deplatformed, done, suspended, yep, shadow banned, yep, deboosted, restrict access to content or other adverse action against any speaker, content, or viewpoint expressed on social media. We've got it all, baby. On June 17th, the plaintiffs filed a motion for preliminary injunction, and the response was filed again. So they go through some law and analysis, and I'm not going to spend a lot of time on this. But the government says that the court doesn't have jurisdiction because the plaintiffs don't have standing. But they say, yeah, they do. The court must determine whether they do have standing. And she says there is, in fact, an injury, it looks like. They have standing to regulate the enforcement of their laws. There's a traceable link here. There is redressability. So these are all sort of the standard preliminary questions in order to sustain a lawsuit. Now here, they're going through some other case law, and the judge gives us this conclusion. She says, if Missouri and Louisiana do not have standing under these facts, when could anyone ever have standing to address these claims? Therefore, they must have standing. In conclusion, the court finds the plaintiffs do have standing and that the court does have power to hear this case, right? So a lot of like the Trump lawsuits all got dismissed on standing. Here, the judge gives us about 9 pages of analysis and says there is standing. So now, right, since they can bring their lawsuit and this thing is not going to be immediately dismissed, plaintiffs state, and the states are seeking an order now allowing the expedited discovery. So they want that stuff quickly, right? They want all this stuff now. And the courts are going through this, talking about expedited discovery, saying it's not usually the norm. Normally we go slowly on this thing. We don't sort of urge people to like pick up the pace on disclosure. Like get your disclosure in according to the rules. They're asking for this to go faster. But now they have to ask themselves, should we grant this? In the motion, the states are saying that they want stuff from the social media companies. Here's what they want. Targeted interrogatories. So interrogatories are like a set of questions, sort of like a big list of questions. Targeted lists of questions and document requests to the government defendants requesting the identities of federal officials who are or have been communicating with social media platforms. Ooh, this is juicy. About disinformation, misinformation, malinformation, or any form of censorship or online suppressed speech. Okay, that's juicy as can be. That means that the state attorney generals are going to be able to assemble a big list of stuff and send it right over to Zuckerberg and his people and say, who are you talking to over there? Targeted interrogatories, serve third-party subpoenas, and all of that. The court then, right, that's their proposal. So the court is going to determine whether there's good cause or not. And they give us some of their analysis. Each one of these is sort of like a tier of analysis, right? So the judge is saying, well, what's the purpose of this expedited discovery? Why do you need this, states? And they say, well, the purpose is to gain additional evidence to prove allegations that they are bringing forward in their pending motion for a preliminary injunction. So the proposed discovery is tailored to what they are seeking. Therefore, it is not a fishing expedition, and the judge is going to grant it. So now we see exactly what the judge is going to flesh out for us. Okay, this is where it's being granted. Although there is certainly a, quote, need for speed, the judge puts that in quotes, very fun judge, for a discovery related to a preliminary injunction, the plaintiffs state that the proposed schedule is too fast. Therefore, the plaintiff state's proposed schedule is too fast. So the judge is saying, okay, look, states, you really want this stuff and you want it like quickly. Okay, it's a little too quick, but you're right. We can pick this up a bit. The court adopts the following schedule for the expedited discovery and or motion. All right. So this means now that the judge is granting this. Within 5 business days after this ruling, the plaintiff states, so Missouri and Louisiana, they may serve interrogatories and document requests upon the government defendants, third-party subpoenas, check this out, on up to 5 major social media platforms. Oh, that is so good. Oh, 5 major social media platforms. Within 5 business days, the states may serve interrogatories upon 5 major social media platforms seeking the identity of federal officials who have been and are communicating with the social media companies about disinfo, misinfo, malinfo, any censorship, any suppression, and the nature and the contents of those communications. Oh, that's just outstanding. That's just amazing. So that means that those 2 attorney generals are going to go, they're probably typing them up right now. They're just tap dancing away on the keyboard, just going hard. Within 30 days, now here's where this gets a little bit, interesting. Okay, within 30 days of the plaintiff state discovery request, responses and objections shall be provided by the government defendants. Okay, so they're going to send over the list. It's like a grocery list. I want all of these things. And they're going to say, you can't have those. No, you don't get, the double stuffed Oreos. Okay, take it easy. You're not getting those. And the judge says, yeah, you really don't need those. Okay, so putting those back. Within 10 days following receipt of the objections, the parties shall meet and confer about the disputes. 7 days after that, the court's going to rule on the objections. 10 days after that, we're going to have production of the responses. 7 days after that, the parties are going to meet again, and so on and so forth. Plaintiffs are then going to have 30 days to take any authorized depositions. Oh, and within 20 days after that, states are going to supplement their memos, and we're going to have supplemental memos, and then we're going to have a reply. In the due course, the court will now rule on the plaintiff's motion for a preliminary injunction. Conclusion entered on July. Terry Dowdy, U.S. District Judge. And you go, whoo, all right. Okay, that sounds pretty good. Pretty good there, Judge. Now, as this happened, right, as this happened, take a look at this filing that came in over from the defendants. So same day, take a look at this one. Okay, on July 12th, same day that the order came out, on 7/12, the judge made, ordered, give them those documents. On the 12th, the defendants, so this one is the defendants' motion, the defendants, Joe Biden, Psaki, Fauci, all those people, they filed a motion to dismiss for a lack of subject matter jurisdiction and failure to state a claim, right? Now they're saying, okay, we want a dismissal because they shouldn't have even brought this lawsuit to begin with. Now, I'm not going to go through this in its entirety. It is a whopper of a motion. Let me see. It's 79 pages. But let me just show you kind of the table of contents so you can get the highlights of this. This to me means that they are freaked out. Okay, they're panicked. They want this case dismissed. They do not want to go through this discovery process. They do not. There's a federal judge that just ordered Facebook to give the names of all the people that they were colluding with from the government, all of them. So the government is now going, whoa, that's not good. We want a motion to dismiss this puppy. And they filed that the same day the order came out, probably because they knew the order was coming out. And they say, look, for years, the background, this is their argument. It's 65 pages. It's like a, small pamphlet here. But they say the separation of powers doctrine requires dismissal of the president from this action. Okay, boot the president off of this. The state fails to state a claim, says that there is no First Amendment claim here. There isn't even coercion or similar degree of encouragement, right? They can't prove any of this stuff. And they can't make the allegations that are needed to sort of properly plead this case forward. They say social media companies have sought to contain content on their platform that they identify as misinformation. Various branch officials have spoken about the harmful effects of this, and basically that they're entitled to do this, right? So a big dismissal order. Now, we don't have a ruling on it because we're not going to get another. So here's the final order that came out from the judge setting deadlines. The motion to dismiss for a lack of jurisdiction that we just read through. We have a response to the motion that's due on August 3rd, 7 days after that. And then the judge is just going to rule. Now, take a look at this. In this court, there's going to be a ruling without oral arguments even on this case. So there's not even there's no oral arguments. Put it in your brief. That's it. So the state attorney generals now are responding to this motion, right? So this is a very important motion. This is their basis for the dismissal. The judge, and it's 79 pages. I don't think, you can see it up there, 79 pages. And the judge is going to be asking the states to respond to this, and we'll see what the ruling is. But won't be any oral arguments. Sometime maybe mid-August, we'll see if this case is dismissed. Otherwise, we may see some pretty interesting discovery come out from these defendants, meaning the government and all of the social media companies. They're not named as defendants, the social media companies, but they are the people that have the names of who they were talking with. Was it Fauci? Was it Fauci's staff? Was it Jen Psaki herself? Was Joe Biden in there? Instant messaging away? Who knows? But hopefully we get some good answers. I would love to know who is behind it all.